We are proceeding. This is the ruling of the Court of the Objections. Ruling on objection by Colonel Retired Dr. Kizza Besigye and another to be tried by a general court martial. The two accused persons were brought before this court for pre-taking and raised objection on the ground that they are civilians and therefore cannot be tried by this court. In reply, Counsel Raphael Mujshala and Counsel for the State submitted that jurisdiction to try a person not otherwise subject to military law is provided under Section 117 of the UPDF Act. This court has looked at Section 117 G and H of the UPDF Act and finds that the accused persons are subject to military law. The objection is therefore overruled. We so rule. And listen to the charge sheet. The Republic of Uganda, Uganda People's Defense Forces, the General Court Martial holding at Makindye, Kampala. Criminal case number UPDF stroke GCM stroke 040 of 2024. A charge sheet. Uganda versus A1 ROV 0098, Colonel Retired Dr. Kizza Besigye, a male adult of sound mind, aged 67 years, resident of Kasangati Town, Nago Sub-County, Nansana Municipality, Wakso District, a person subject to military law by virtue of Section 117, subsection 1HI of the UPDF Act, cap 330, and A2 Haj Obeid Rutale, a male adult of sound mind, aged 65 years, a resident of Mutundo Village, Mutundo Parish, Makindye Sabagabo Sub-County, Busiro County, Wakso District, a person subject to military law by virtue of Section 117, subsection 1, HI of the UPDF Act, cap 330, are hereby charged with statement of offense on count 1. Offenses relating to security contrary to Section 128, subsection 1F of the UPDF Act, cap 330. Particulars of offense. Colonel Retired Dr. Kizza Besigye, Haj Obedia Rotary, and others still at large between October 2023 and November 2024, while in cities to wit Geneva in Switzerland, Athens in Greece, and Nairobi in Kenya, held meetings aimed at soliciting for logistical support and identifying military targets in Uganda with intent to prejudice the security of the defense forces. Colonel Retired Dr. Kizza Besigye, have you heard and understood the charge read to you on count 1?
I have.
Do you accept or you don't accept?
Don't.
A plea of not guilty entered. Haj Obedia Rotary, have you heard and understood the charge read to you on count 1?
Yes.
Do you accept or you don't accept?
I don't accept.
A plea of not guilty entered. Statement of offense on count 2. unlawful possession of firearms contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel retired Dr. Kizza Besigye Haj Rotary on 16th November 2024 while at Riverside Apartments in Nairobi, Kenya, were found in an unlawful possession of a pistol model 27 KAL number 765, which is ordinarily the monopoly of the Defense Forces. Colonel Dr. Kizza Besigye, have you heard and understood the charge read to you on count 2?
I have.
Do you accept or you don't accept?
Don't.
A plea of not guilty entered on count 2. Haji Besigye, have you heard and understood the charge read to you on count 2?
Yes.
Do you accept or you don't accept?
I don't.
A plea of not guilty entered on count 2. Count 3, statement of offense. Unlawful possession of firearms contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel retired Dr. Kizza Besigye Haj Rotary on 16th November 2024 while at Riverside Apartments in Nairobi, Kenya, were found in an unlawful possession of a pistol HB 1014-1953, which is ordinarily the monopoly of the Defense Forces. Colonel retired Dr. Kizza Besigye, have you heard and understood the charge read to you on count 3?
I have.
Do you accept or you don't accept?
Don't.
A plea of not guilty entered. Haj Rotary, have you heard and understood the charge read to you on count 3?
I have.
Do you accept or you don't accept?
I don't.
A plea of not guilty entered on count 3. Count 4, statement of offense. An unlawful possession of ammunition contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel retired Dr. Kizza Besigye Haj Rotary on 16th November 2024 while at Riverside Apartments in Nairobi, Kenya, were found in an unlawful possession of 08 rounds of pistol ammunition, which are ordinarily the monopoly of the Defense Forces. So, Colonel Dr. Kizza Besigye, have you heard and understood the charge read to you on count 4?
Yes, I have.
Do you accept or you don't accept?
Don't.
A plea of not guilty entered on count 4. Haj Rotary, have you heard and understood the charge read to you on count 4?
I have.
Do you accept or you don't accept?
I don't.
A plea of not guilty entered.
Investigations are still ongoing. I pray that the accused persons be remanded. Accused person number 1 is the government prison, and accused person number 2 is cheated the government prison. And I pray that the case be adjourned for further formation on the 2nd of December 2024.
Confirm the date registrar. Huh? Which date?
Okay.
This is Mr. Chairman and honorable members. My name is Zebamuvunanye.
We are together with the Wanda Martin, Ronald Samuel, and Bayani Trinawe. Mr. Chairman and honorable members, we are raising two objections, Mr. Chairman. One in regard to the order that has been issued regarding the remanding of the accused persons in separate facilities. We take exception to that. Mr. Chairman, they are jointly charged. As per the charge sheet, they were arrested together. They have been detained together. So it would be irrational, Mr. Chairman, and unreasonable to remand them in different facilities. In other words, there is no justifiable reason for them to be remanded separately. The justice of the case would demand that since they are jointly charged and they have to prepare a joint defense, they should be in the same facility where they can access their lawyers to effectively give instructions on how to manage this matter. It will be a great inconvenience to the accused persons and their lawyers to be in different facilities, Kitali and Ruzira, without having any point where they can converge and discuss their joint defense, because they are on one charge sheet. So in the interest of justice, we pray that the order be revisited and they should be remanded in one place. The most fundamental objection, Mr. Chairman, relates to the nature of the proceedings before this honorable court. And that is our second objection. Mr. Chairman, regards it's about the propriety of these proceedings before this honorable court. It's our strong contention, Mr. Chairman, that these proceedings are a nullity, considering the charges that have been preferred against the accused person. If I may be permitted to substantiate, Mr. Chairman, when you look at the particulars of all these 5 counts, 4 counts rather, they relate to offenses allegedly committed outside the jurisdiction of this honorable court. The first count talks about acts allegedly committed in Athens, Greece, Nairobi, and elsewhere. And Mr. Chairman, this honorable court has no jurisdiction whatsoever to deal with offenses allegedly committed in Greece, Kenya, and Switzerland. Mr. Chairman, that applies to count 2, which talks about Riverside apartment in Nairobi, where it's alleged that on the 16th of November this year, the accused persons were found in possession of a pistol, model 27 KAL number 765. And also count 3, which talks about the same place, Riverside apartment in Nairobi, Kenya. And count 4, the same place, which talks about ammunitions. It's nowhere in these charges. There is nowhere in this charge sheet where it's alleged that all these acts, the impandi acts, were committed within the jurisdiction of this honorable court, that is the territory of Uganda. Mr. Chairman, this court has got no universal jurisdiction for the entire world. That would be stretching the jurisdiction of this honorable court to levels of absurdity, that it can deal with any matter that is alleged to have been done, or any act or offense that is alleged to have been committed anywhere in the world. I would refer you, Mr. Chairman, to the provisions of Article 28, Clause 7, which provides that no person shall be charged with or convicted of a criminal offense which is founded on an act or omission that did not, at the time it took place, constitute a criminal offense. So in this particular case, Mr. Chairman, all the acts referred to here in this charge sheet, or highlighted in this charge sheet, do not constitute criminal offenses within the meaning of the laws of Uganda, because the UPDF Act applies to Uganda and doesn't apply anywhere else. The boundaries of its application, the boundaries of the UPDF Act, are the confines of the territory of Uganda. It does not extend to Kenya, neither does it extend to Switzerland or Geneva. It is not a law applicable there. It's the reason here, Mr. Chairman, in the charge sheet, which we find to be incurably defective, it does not make reference to the laws of those respective countries where these acts are alleged to have been committed. Unlawful possession of firearms, contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Firearms Act of which country? Because we are talking about here Riverside, Kenya. And in law, this is considered to be a duplex charge sheet, which is ambiguous in nature. So the accused persons cannot understand the nature of the particulars of the charge sheet as they are spelled out in these particular counts. Because, Mr. Chairman, you are talking about Firearms Act of which country? Then we are talking about in County 4 on 16th of November 2024, while at Riverside Apartments in Nairobi, Kenya, Colonel Dr. Kizza Besigye and Haji Obedi Rutale were found in unlawful possession of 8 rounds of pistol ammunition, which are ordinarily the monopoly of the defense forces. Of which country? Because we are talking about Riverside Apartment in Kenya. Are they a monopoly of the UPDF or KDF? In which case, this would determine the nature of the pulley given by the accused persons as to whether the acts amount to an offense or not. So this is a defective charge sheet, Mr. Chairman, which should not sustain any criminal proceedings before this honorable tribunal. Lastly, Mr. Chairman, on count 1, offences relating to security, contrary to section 128(1)(f) of the UPDF Act, we presume this is Uganda People's Defence Forces Act of Uganda. That is the presumption, a rebuttable one, depending on the evidence given by whoever is preferring this charge. But we presume that they meant the forces of Uganda. This is again an absurdity, Mr. Chairman. Because when you talk about acts under the particulars of the offense, which relate to acts allegedly committed in Geneva, Switzerland, Athens in Greece, and Nairobi in Kenya, and you relate them to the UPDF Act of Uganda, it's a narrative from the word go. So, Mr. Chairman, it's our prayer that this honorable tribunal be pleased to dismiss the charge sheet. To strike out, Mr. Chairman. It's our prayer, Mr. Chairman, that this honorable tribunal be pleased to strike out this charge sheet and accordingly discharge the accused persons, because as far as this charge sheet is concerned, there are no cases that should be preferred against them within the laws of the Republic of Uganda. Finally, Mr. Chairman, the accused persons have been illegally presented before you, Mr. Chairman. The 2 accused persons here traveled to Nairobi lawfully for a legitimate activity, which was never in any way questioned by the security agencies and were cleared by the immigration authorities of Uganda. So they have been in Kenya lawfully, or they entered the Kenya lawfully. And Mr. Chairman, once you are in a foreign territory, you can only be returned forcibly through the due process of the law. If you do not return voluntarily and there are forces compelling you to return, they have to follow the due process. And there are only 2 ways under the law. Either extradition, that is under the Extradition Act of Uganda, or deportation. In which case, Mr. Chairman, if it's about extradition, it has to be upon a request of the Minister for Foreign Affairs that they are facing charges in Uganda here, and they are fugitives in Kenya, and they are demanding for assistance of the neighboring country to repatriate them back. We are not advised, it's not anywhere on record, Mr. Chairman, that has happened. It's not on record. If you are to be a deportation, it presupposes that they entered the country illegally, or having entered the Kenya legally, they committed offenses in the Kenya. Again, it would be the authorities in Kenya to handle that. And they have to go through the judicial process in Kenya. Deportation has to be by a court order given by the Kenyan authorities, Kenyan courts of law. So in this particular case, Mr. Chairman, the record does not bring out those facts, that they were either extradited or deported. And according to Mr. Chairman, the Human Rights Enforcement Act of Uganda, once proceedings are rooted in a narrative, Mr. Chairman, this Honorable Tribunal has no choice but to terminate the same. It's our contention, Mr. Chairman, that the accused persons have been illegally produced before you. They have not been repatriated, rather deported, neither have they been extradited. And if anything, Mr. Chairman, they have not even gone through the immigration back here. As we stand today, they are presumed to be in Nairobi, in Kenya. The law presumes that they are still in Kenya. It would be a very, very absurd situation, Mr. Chairman, for this honorable court to sit here to handle cases or matters involving the two individuals who are currently standing in Nairobi. In the dock where they are standing here, the law presumes that they are in Nairobi, and the court is sitting in Uganda. So, Mr. Chairman, that is an absurdity which cannot be condoned by this honorable court, honorable tribunal. So on those grounds, Mr. Chairman, we pray that you be pleased to strike out to the charge sheet, dismiss the case, set the accused persons free unconditionally, and have them discharged. We do so, Mr. Chairman.
Chairman and honorable court members, jurisdiction is a creature of statute. And section 280 of Uganda People's Defense Forces Act, which is an act of parliament, states a person alleged to have committed a service offense may be charged or dealt with and tried under military law, whether the alleged offense was committed in Uganda or out of Uganda. So to say that an offense which was committed as there is Nairobi and that section resolves that. My Lord Chairman and all the members, on the issue of extradition, that one can be addressed at the, it will be addressed, it can be his defense, and it should not be addressed at this stage. What is the evidence which has been produced before this honorable court that retired Colonel Dr. Kizza is supposed to be in Nairobi? That evidence has not been available before this honorable court. You are acting, you are submitting on speculation. So, we pray that council people
Runesa Properties yifeba kabaka mu kutunda amataka g'ebyapa n'ebibanja era nga tukuletedde estates ne properties ez'enjawulo okwetooloola eggwanga lyonna ku ssente ez'owansi okutandikira kakadde kamu n'ekitundu okugeza Nakifuma Kateete 25 ku miliyoni 1.5 5 ku 10 ku miliyoni 6 Namalirika Kuukulu 5 ku 10 miliyoni 6 25 ku miliyoni 1.5 tulina poloti ebugema okuliraana emabega wa university 5 ku 10 ku miliyoni 12 zokka na 5 ku miliyoni 6 zokka nga kwoteeka 25 Offices zaffe esangibwa Kasangati ku 10 okulira na Equity Bank. Tukyalireko leero tukutuuse ku ttaka ly'ekirooto kyo ate ku bbeeyi layisi. Ate nga ku Ronesta Properties tukuyambako n'okulaakulanya ettaka lyo nga tukubira pulaani z'amayumba ez'omulembe kw'oteeka okuzimbira. Okumanya ebisingawo tukubire ku nnoti 774 12 07 10 ne ku nnoti 704 27 41 28. Ronesta Properties, let's guide you home.